If your company's heading towards liquidation or you're even just worried about it, stop right now because I'm going to explain exactly what happens when your company goes into liquidation, step by step, clearly and simply, so you know how to protect yourself, your home and your personal finances. There are thousands of UK directors right now facing insolvency, but most directors have no idea what's really involved. They're scared, confused and often misinformed. They worry they'll lose everything, the homes, the savings and the reputation. And because they don't understand clearly what happens during this process, they make mistakes that can cost them personally. But it does not have to be that way. Knowing exactly what liquidation involves, what steps happen next and how you can protect yourself is absolutely essential, and that's exactly what you're going to learn today. In this guide, I'm going to break down clearly and simply what happens when your company enters liquidation. You'll learn exactly what liquidation means, no jargon, just clear facts. I'm going to go step by step what happens when liquidation starts, what an insolvency practitioner does in their role, and what happens to your company assets and your company debts once you start the process. And I'm going to talk about exactly how personal liability works and common pitfalls to avoid. I'm also going to go on whether you can restart after liquidation and how you can do that safely. And finally, I'm going to give you a clear action plan to help you take immediate next steps and protect yourself as best you can. It's Chris Worden. I'm from Director First. I've helped thousands of UK directors safely navigate the insolvency process. I have seen directors at their absolute lowest, terrified, uncertain, can't sleep, and I've helped them recover, get back on their feet mentally, physically and emotionally. Now, if you're feeling stressed, overwhelmed or confused right now, I want you to stay with me, because understanding this process can literally save your financial future. Let me have a water. Here is exactly what we're going to cover today. I'm going to talk about what happens at every stage of liquidation. I'm going to talk about common mistakes directors made and how you can avoid them. I'm going to show you how to minimise personal risk and protect yourself. I'm going to give you some practical, immediate steps you can take today. And if you want clear answers, total transparency, and practical advice designed specifically for you, you're in the right place. Now let's start with absolute clarity. What does liquidation mean? Now in plain English, liquidation is the formal legal process used to close down an insolvent limited company. And insolvent just means you can't pay your debts when they fall due, or your liabilities are more than your assets. And when you liquidate a company, it essentially ceases to exist, it ceases to trade. If it has any assets, the assets are sold by the insolvency practitioner and money's raised and distributed fairly among the creditors. They're the people that your business owes money to. After liquidation, the company is legally dissolved. It no longer exists, it disappears. Now, there are two main types of liquidation in the UK. One is creditors' voluntary liquidation, and that's when you have become insolvent and you decide to choose to voluntarily liquidate the business in line with your fiduciary duties, and you find somebody that you want to work with. It's proactive and it's always the best outcome. The other one is a compulsory liquidation, and it's a forced liquidation, and this is initiated by creditors, mainly HMRC, and they force you into liquidation through something called a winding up petition, and it's essentially because you've not paid your debts, and it's stressful, there's no control over the process, and in my opinion it always leads to worse ramifications for the director. For most directors, the voluntary option is not only the safest, it's the best option, and it puts you in control to a degree. And I'm not saying it gets rid of personal risks, but it certainly minimises them, or it allows you to understand them before you hit the button. Okay? Now, before we go any further, let's define some key terms that you're going to hear. One is insolvency practitioner, IP, and this is the professional appointed to manage the liquidation. It's often called the liquidator. Creditors are people or business your company owes money to. Could be HMRC, could be suppliers, could be banks, could be employees. We're going to talk about assets. And assets means everything that your business owns: equipment, stock, vehicles, property, money owed into the business, cash at the bank, website, databases. I'm going to talk about debts and liabilities, okay? Money your business owes. I'm going to talk about insolvency. And insolvency means your company can't pay its debts when they're due, or the liabilities exceed the assets. And if you can understand these terms, it ensures you're informed and you're not missing anything when you're talking to these insolvency people. Now, some of them are just going to spit the Insolvency Act at you. I'm not sure how helpful that is to 99% of directors, so I try and keep things really simple. Right, step one. First step towards liquidation begins the moment that you realise that not only can your company not pay its debts when they fall due, that the liabilities are more than their assets, but you actually realise that you can't overcome this. You're not going to be able to recover. You're past the point of no return. You're getting constantly creditor pressure. You're bloody robbing Peter to pay Paul every month. And you've took a long, hard look at things and you've realised that I'm not going to get over this. Now, if you've seen those signs and you've made that decision, you've now got a legal duty as a director to stop making things worse for your creditors. You've got to put the interests of your creditors above the interests of you as the owner. And the second step would be to seek professional advice from an insolvency professional or an insolvency practitioner. Because once you've acknowledged that you're insolvent, once you've acknowledged that you're not going to get back on a level playing field, you've immediately got to contact somebody like me. And what we'll do here is we will clearly explain what your options are. We'll go through liquidation, administration, CVA. We'll see if it's just an advisory call that you need to do this, that and the other and get yourself back on an even footing. Sometimes it's just a case of negotiating with HMRC. But crucially, a good insolvency professional, the first job will be to try and help you avoid insolvency. But if you can't avoid insolvency, they'll tell you exactly what's going to happen. And if liquidation is the best choice, you'll get a proposal off that insolvency professional and you'll make the decision to appoint that liquidator. And step three, that's what it is. It's like the formal decision. Because once insolvency practitioner's been chosen and you've basically give them all the paperwork that they need, there's a lot of paperwork sadly in insolvency, they're going to start the process. And this is what happens. There's a board resolution. So the directors formally agree to place the company into liquidation and it's documented. You stop to cease trading, okay? Then you're right to notify your creditors. Well, the insolvency practitioner will formally contact all the creditors. They'll write to HMRC, suppliers, lenders, and they'll tell them of the pending creditors meeting. Then the creditors meeting happens, okay? So at this stage, creditors can start to formally submit their claims to the insolvency practitioner, basically saying what they're owed, when they're owed, proving their proof of debt essentially. And then at the creditors meeting, the insolvency practitioner that you've appointed will take the appointment and they're in the hot seat now and they're going to be there to investigate the conduct of the director. I'm going to sneeze. Excuse me. I hope that wasn't too loud for those listening in the car. Now, one of the most important people you're going to deal with during liquidation is the insolvency practitioner, okay? And you're probably wondering, well, who are these people? Now, an insolvency practitioner is licensed and regulated, okay? And they're experts and they're actually there to represent the creditors of the company. So they're there to recover funds for HMRC, for your suppliers. They've got a duty to act in the best, certainly the interest of the creditors. And the responsibilities include selling assets, and if they get some money in, they can distribute those to the creditors. They're going to handle all creditor communications, and they're also going to investigate you, the director, into your conduct. They're not there to represent you personally, they're there to represent creditors first. But if you choose a good one, a reputable one, we can help you with that. They will ensure that the process is fair, transparent, and most importantly, professionally managed. And that ultimately will lead to a better outcome. Now, people need to understand that an insolvency practitioner has significant powers, okay? They control all the company's assets. They will sell them as they see fit. It has to be transparent. But more importantly is they've got a legal right to investigate the company's finances, and they're going to be looking at what you've done as a director to get it into this position. Now, they will decide based on how much people are owed and what hierarchy they are to get paid on how much each creditor will get paid. And they're also going to report. They will report directly to creditors and to people like the Insolvency Service about what's gone on. Now, you must understand that these powers, they are significant. And if they've seen any wrongdoing, it could lead to personal liability. What you don't want to do is appoint an insolvency practitioner and bury your head in the sand thinking they're just like a creditor that you've been ignoring. They will not be ignored, okay? And they can take things to the nth degree and cause you huge problems personally if you don't comply. I'll tell you exactly what the insolvency practitioner does. So once they've been appointed, they take control, okay? So they have full control of the business from that day. They've also got to inform creditors. They've got to communicate with creditors what's going on. They'll get claims in from creditors and they'll answer queries. If there's any assets in the business, they'll get the assets valued and they'll oversee the sale of the assets. And they're going to, in every case, they're going to review the company's financial history and they're going to investigate you as a director. That is their job, checking for improper conduct. Then they're going to report. They're going to report to creditors, they're going to report to the regulators, the Insolvency Service, and eventually they'll close the company down. That can take 12 months as a minimum, okay? Now, as long as you understand what a liquidator does, you're sort of prepared. What they're not there to do is hold your hand, right? They're not there to protect you. Director first are here to give you advice. We can't make problems go away. We can't sweep anything under the carpet. We play within the rules. But what we do is we help make sure that you're fully prepared for what's about to happen. And in the process of that, hopefully we can minimise the risk a little bit. Now, one of the things that people will ask is, can I buy the company assets before I appoint the liquidator? And the truth is, yeah, absolutely you can do. You can buy your company assets, but you must have them valued independently and you must pay a fair market value to them. So what I'd suggest is, if you're thinking about selling your company assets, get an agent involved. We'll help you oversee this. They'll value your assets. You'll make an offer to the agent. Essentially, what you've got to make sure that the agent agrees it's a fair offer, and then we'll speak to the insolvency practitioner and hopefully agree you some terms to pay it over. If the insolvency practitioner is going to sell the assets on your behalf, essentially they'll still get an agent to value it, and they will sell it to fair market value to somebody who wants to pay for it. Now, once they've sold those assets, you need to understand what happens to the money and where does it get distributed to, because there's sort of a hierarchy of who gets paid. First person to get paid is the secure creditor. So this could be a bank, it could be someone who's got a charge over the company. Second person to be paid is the insolvency practitioner's fees and all the professional costs. Then it's preferred creditors, and it's like certain employee claims, unpaid wages, redundancy payments. Remember, HMRC are now a preferred creditor. And if there's anything left after all those have been paid, unsecured creditors will get some of their money back. It's highly likely in most insolvencies that by the time this happens, there's very little left. And then obviously the bottom of the chain is the directors and connected parties. So, in most insolvencies, once a secure creditor is paid and an insolvency practitioner is paid, very little is going to trickle down down to people below. Now, you're probably wondering what happens to company debts in liquidation. Now, when your company enters liquidation, the debts that the business owes typically remain with the company, okay? So you as a director don't automatically become personally liable for these debts. They actually stay with the company. And a lot of those debts are written off. So unsecured debts like suppliers, unpaid rent, utilities, bounce back loans, C-bills for less than £250,000, HMRC debts, that's VAT, corporation tax, PAYE, they actually get written off in a liquidation. And that's what, so once you go into liquidation, you as a director can stop worrying about those debts. One of the things that people ask me all the time is, am I going to be made personally liable for a bounce back loan or an HMRC debt? And in 99% of cases, certainly with the HMRC, you will not be made personally liable unless some serious wrongdoings happened, and then you get issued with something called a personal liability notice. Bounce back loans is a little bit different. Let's dig into them. There's no personal guarantee on a bounce back loan. So in a liquidation, the government will step in and pay the liquidator and the loan will get written off. But if you've misused the loan, spent it on personal things like a new car or a new watch, or you've took a loan wrongly, okay, that is where you are going to be made personally liable. If you've misused that bounce back loan, if you've took too much, that is a problem and the insolvency practitioner will chase you for it. You also get made personally liable for personal guarantees. Obviously the clue's in the name. And that's where you've signed a personal guarantee to a supplier or a bank or a credit card and you go through an insolvency process. Once you're in the insolvency process, that debt crystallises and that supplier, bank or credit card wants paid. In 99% of cases though, you'll be able to restructure those personally guaranteed debts over a longer period of time. Again, as part of our service at Director First, we'll help oversee all that and we'll introduce you people who can help you negotiate personal guarantees. Now, it's really important you understand this bit, and that's where I talk about director investigations. Because once you appoint a liquidator, they are going to investigate what's happened. They're going to look at the transactions, they're going to look at all payments made prior to liquidation, especially large payments. They're going to investigate your director's loan account. They're going to see whether or not you owe the company money, and if you do owe the company money, they're going to ask you to repay that money back to the company. It's dead important you understand this point before you make any decisions when it comes to liquidation, okay? Overdrawn loan accounts can make you personally liable. They're also going to look at preference payments, and that's where you pay one creditor over another unfairly, and if you've done that, it's highly likely they could make you personally liable for there as well. You've got to understand these risks before you make any decisions, okay? So what I hope this video has helped you to do so far is to understand some key issues. And one of the questions I think you've probably got now is, if I liquidate my business, can I restart it and start another one? And the answer is, yeah, you can. Like, okay, liquidation will legally close this insolvent business, but it doesn't automatically stop you running from another one. I mean, literally, you can be the director of as many companies as you want, as long as you behave properly as a director, you file your returns on time, and you act responsibly. Now, if you want to start a new company, please speak to your insolvency guy about, how do you feel that my conduct's been? They should be able to give you a good indication at the start. If you tell them everything, what the chances are of you being blooming disqualified. But step one, if you're going to do this, you need to form a new company. And if you're going to form a new company, be careful what you call it, because you're not meant to use the same or similar name for a period of 5 years. Now, you can buy that name back from the liquidator on the day of liquidation, and if you do that, there's some hoops that you need to jump through, like advertising in the London Gazette and actually writing to your creditors. So, again, we'll help you with that if it's something you want to look at. If you're going to be selling assets, make sure that you've had them valued. Make sure you've had them valued independently and that you've spoken to the insolvency practitioner about how much you're going to buy them for. Remember, your insolvency practitioner can and will give you terms. So what's the plan now? Well, first of all, in the first few days, if you've recognised insolvency and you think you're not going to be past that, you're not going to get back on a even keel, pick the phone up to us today, okay? Let's help you understand what's going on. We also think you need to get your books up to date. You know, at the very least, get an up-to-date balance sheet and an up-to-date list of creditors so we know exactly who it is you owe. Obviously, once you've got advice, we'll talk through the various options that are available: liquidation, CVA, administration. And once we've done that, we'll give you a full proposal so you understand absolutely everything before you decide to make any decisions on this. So you've got a clear choice to make immediately. Do nothing, keep your head in the sand and risk personal liability down the line, or act immediately and get some professional advice, and hopefully that will protect your personal finances. I hope you found this video useful. My name is Chris Worden. God bless you. I'll catch you soon.